John Weihn here, attorney and legal instructor for Blue to Gold Law Enforcement Training, bringing you another Roadside Chat, doing what we can to help you make sure you get it right every time. Today's question comes from an officer in Arizona, and the question is this. At 3:12 in the morning, a citizen calls in and reports that their Ring camera captured a male walking up to their vehicle, pulling on the door handle. The car was locked, so the subject then walked away. The citizen provided a good description, right? White male, clothing description, hairstyle, and 500 yards away, another reporting party calls in and describes the same subject as walking through the neighborhood, 3:12 in the morning, being suspicious. Officer comes in just north of, and he sees another subject. Now this subject doesn't match the description of that provided by the callers. However, that subject turns around, sees the officer, and immediately takes off running. As he's running from the officer, another guy runs from a driveway, and that guy matches the description provided by the callers. They meet up, and they run together. Officers stop the subject, they detain him, they separate him, they contact the original reporting party, and then officers go through, they check surrounding houses for vehicle burglaries, and 3 houses down from that original caller, they find a vehicle with the driver door open and papers everywhere. So the question is, based on these facts, when are we at reasonable suspicion? When are we at probable cause? And it's funny because we talk about reasonable suspicion, we talk about probable cause, we deal with these concepts every day, thousands of times a day, and yet the question is, how do we define them? And it's not easy, and it's not easy for us, and it's not easy for the courts, and in fact the courts have refused to define them. In the 1996 case Ornelas versus United States, the Supreme Court described the concepts of reasonable suspicion and probable cause as fluid concepts, and they went so far as to say they're impossible to define. Really, they're common sense, non-technical conceptions that deal with the factual and practical considerations of everyday life. And they are ones on which reasonable and prudent men, not legal technicians, act. So it's not easy. It's difficult. And the court went on to say that they're not readily or even usefully reduced to a neat set of legal rules. And so reasonable suspicion has been defined as specific articulable facts that would lead a reasonable officer to conclude that the subject is, was, or is about to be engaged in criminal activity. Okay? All right? And then when we talk about probable cause, that's known facts and circumstances sufficient to warrant a person of reasonable prudence to conclude that a crime has occurred and this person is the one who committed it, right? It's also been described as a fair probability that this person committed a crime, all right? So when we talk about the facts of this specific instance, a case that is really applicable and really on point is a 1968 called Peters versus New York. And this is kind of a fun case, and I would highly recommend you read it. So the situation is this. An off-duty officer is in his home, right? He's in his apartment, and he hears some scuffling and some noises outside. And so he looks through the peephole, and he sees 2 subjects walking down his hallway, and they're tiptoeing and they're trying to be sneaky. And he's watching them for a while, and then they start moving off down toward further down the hallway, and he's concerned that they're thinking about burglarizing houses. So he exits his apartment, he slams the door behind him, and as he does so, the 2 subjects kind of start, and they turn around and they look at him, they go wide-eyed, and they take off down a stairwell. And so he gives chase, right? He detains one of them, and then he conducts a pat-down, and while he conducts that pat-down, he feels a hard object in the pocket of one of the subjects, and he's concerned it might be a weapon, so he pulls it out, and it turns out it's burglary tools. And the court, in reviewing this, the Supreme Court said that was, when he seized him, he was at probable cause for burglary. Okay? Probable cause to arrest for burglary at the time when he seized him. And the interesting thing about this case is they went into detail about the officer's background, his training, his experience, and what he observed, right? And a factor that they considered is that he was in his home, right? He was in his apartment, and he was intimately familiar with that complex. He was familiar with who should be walking down that hallway, why they should be walking down that hallway, time of day, right? And all these factors went into it. So his personal experience as well as his background and his training combined to say, hey, this was unreasonable. All of these facts, all of these circumstances led him to conclude that there was a fair probability that these guys were engaged in criminal activity, and there was probable cause for their arrest based on his observations and based on his articulations. Okay? So, when we talk about reasonable suspicion, the biggest case on point, the one that I always go to, a favorite one of mine, is Illinois versus Wardlow. Okay, that's a 2000 case, and that talks about the facts and circumstances, reasonable, articulable suspicion that criminal activity is afoot. Okay, and when an officer has that reasonable, articulable suspicion, they may conduct that brief investigatory stop. Okay. And it's based on the totality of the circumstances. So all of the factors, everything at play there is what's going to go into making that determination of reasonable suspicion. In that instance, they talked about headlong flight, right? And headlong flight, which is what we're dealing with here in the situation. And the court said that headlong flight in and of itself is not enough. Presence in a high crime area is not enough. But the combination of headlong flight, unprovoked headlong flight, in combination of being in a high crime area, is reasonable suspicion and gives officers the basis to stop somebody, right? So the court in that case said that citizens should be free from ignoring police and going about their business. However, headlong flight, which is the consummate act of evasion, is the exact opposite of going about one's business. So when we apply these two cases to the fact pattern at hand, when you see a subject, even if they don't match the description of the person called, right, who was called on, time of day, no other foot traffic in the area, are we in a high crime area, is this an area known for vehicle burglaries, okay? You see this subject, he sees you, he turns, is he making nervous, evasive actions, right? Does he do the one time? Do his eyes go wide, right? What clothing is he wearing? And then obviously that consummate act of evasion, that headlong flight, that's going to give you reasonable suspicion all day long if you can articulate those other factors, okay? When you combine that headlong flight with a call for service, a known, not anonymous, call for service in that same area, you're good, okay? Then we combine that with the fact that the other subject ran out and met him. Now 100% obviously you're good, right? Because that guy matches your description that was provided by the caller. So the question then becomes, when are we at probable cause? Well, if we're applying Peters versus New York, when the subject takes off, right? As long as you can articulate all those factors. Are you familiar with the area, time of day? I mean, we have what that person called in and described. That person called in and described a crime, right? Attempted vehicle burglary. So, when that subject takes off, you've definitely got reasonable suspicion. And then when his partner comes up and meet up with him and they run in tandem, well, if you're applying Peters versus New York, you've got probable cause. Now, we combine that with calling the reporting party, getting that information, confirming it, you're good for attempted vehicle burglary, and then when we find that other vehicle in the area, right, we're talking about temporal proximity, we're talking about physical proximity, that vehicle has been burglarized, you are at probable cause. If you want to say proof beyond a reasonable doubt, well, you're going to have to take additional steps, right? You're going to have to contact the owner of that vehicle, say, hey, did you leave your vehicle like this? No? Okay, the door's open, papers all over the place, you didn't leave it like that? All right. Time of day, temporal, physical proximity, you are good. You get that arrest for probable cause, conduct that search incident to arrest, make that determination if they've got any property, and proceed. It's a great question. It's a lot of fun. Please review Peters versus New York, review Illinois versus Wardlow. If you have any questions about reasonable suspicion, if you have any questions about probable cause, those are going to be your two on-point cases for this fact pattern. If you guys have any questions, please don't hesitate to email me, john@bluetogold.com. We will do what we can to help you make sure you get it right every time. Until next time, be safe out there, watch your back, and we'll see you soon.